The outline of this lecture is Introduction to Cyber Law, Need of Cyber Laws, Cyber Law in India, including the history of the cyber law, cyber crime, what are the categories of cyber law, important definitions listed in the IT Act, various sections of IT Act 2000 and Amendment 2008. So here you have seen ASSOCHAM stated one observation about the cyber crime is that India has witnessed a 457% rise in cyber crime incidents under the Information Technology Act 2000 from the year 2011 to 2016. It means it's a very huge number of cyber crimes listed by the NASSCOM. India is becoming vulnerable in digital world due to the combination of digital illiteracy and immaturity. This graph shows that the cyber crime reported in India is the 3% of worldwide, whereas the United States of America is affected 23% of cyber crimes listed in the world. It means that India is also in the category of affected countries in the digitization, especially in cyber crimes. So therefore, increasing diverse barrage of cyber attacks also exist in India. Another observation is that 3% of total systems across the world is controlled by the criminals, and these criminals are very smart, and these are the cyber criminals. Now, what is the cyber law? Basically, cyber law is the law governing the cyberspace. Now, the question arises that what is the cyberspace? So, the cyberspace is the environment for communication over computer network within a nation boundary. It means that within a nation boundary, whatever the field, whatever the thing which is used over the computer network, then it comes under the cyberspace of that particular nation. It includes computers, networks, softwares, storage devices like hard disk, USB device, the intranet, website, emails, ATMs, cell phones, etc. So the whole things are covered by the cyberspace. Introduction of the cyber is an idea, a person, thing can be described with prefix cyber if involved in digital world as a part of computer and information age. So from there the cyber word comes out. So the word cyber is derived from the Greek word cybernetics, which means steersman or governor. So the cyber is the word which is used for the govern something. So this word is first introduced by Norbert Wiener. This is the today's definition, and today's existence of the cyberspace is the cyberspace is the virtual world which is existing over the internet. Cyber laws are the laws to governing this area. So to govern the cyberspace, to apply the laws, to apply the legislation over the cyberspace, we require some laws, and these laws are called as cyber laws. So cyber law is a branch of law dealing the legal issues concerned with information technology and cyberspace, and to governing the computers and the internet. So why we need the cyber law? So due to the more digital sophistication, there is a crime. For understanding the need of cyber law, we have to know the objective of internet. The internet is invented initially with the objective is a tool for information sharing and research. So this is the primary objective of the internet. But now we are using the internet not only for exchanging and sharing the information, not only for the research, but also for e-governance, e-business, e-commerce and e-procurement, and other various applications of internet are also existing in the field. Therefore, the cyber law are dealing with all legal issues related to the internet crime. It means that all the crimes existing over the internet is dealt with the cyber law. Almost all the cyber users are affected by cyber law in today's highly digitized world by various means. Some of the examples are transactions. Transaction means we are dealing with the financial transactions using net banking, using credit cards, using debit cards, using ATMs, etc. So in transaction, what happens? We are dealing or we are simply providing our information to the bank using the internet. Because of the computer network and internet, it may be possible that the cyber attack can attack and simply steal some information for their own purpose. So it is the cause of cyber attack. So we require the cyber law in this particular situation. Another is e-governance. In e-governance, government provide the platform for its various services so that user can access these services using the internet. So because internet exists, so there is a possibility of cyber attack. So we require the cyber law. Another is computer network. We are using IP cameras, we are using various devices which are connected through the computer network, and this computer network also connected with the network of network, which is the internet. So there is a possibility of cyber attack, so we require the cyber law. Various valuable data in electronic form we are using these days. These all are the fields where the cyber law required. We require the cyber law for credit cards, for emails. We are using the income tax return using internet, so we require the cyber law here. We are using cell phones, SMS messages, online banking, online share trading. There are frauds due to the online share trading. So these are some fields where cyber laws required. This is a data to endorse the cyber law. This is the NCRB data. In 2014, 9,622 cases were registered under the IT Act. In 2015, the numbers increased and it is about 11,592 total cases are listed under the IT Act, and in 2016 the cases is increased, the figure is 12,317. It means that day by day cyber crimes are increasing and the listing or registration of the cyber crimes under the IT Act is increased, and it will be reflected by the NCRB data. Now go to the next. So we need the cyber law to development of the department about cyber forensic, because in various cases we require the forensic in especially for the cyber field. So to develop the department for that. Another is the training of the users and therefore develop infrastructure for it. So we have to train the cyber users about to prevent from the cyber attack. Another need is establishment of forensic labs, enforce judiciary on the methodology and procedures about the digital evidences. The training academy of CBI, that is the Central Bureau of Investigation, should be established. A training lab for cyber forensic. It means that government should work in the field of cyber law. So this is the need of current era because of the digitization, because of the increase in the cyberspace. So we require the cyber law here. There are some agencies are established by the government for the basic and advanced training for the cyber laws. These are CERT-in, Indian Computer Emergency Response Team, CDAC, Center for Development of Advanced Computing, DSCI, Data Security Council of India, and the NASSCAM. These all are the bodies, agencies which are deal with the cyber law. Now, the cyber law in India. The IT Act is the second law in the India governing the field of IT in 2000. Why? Because the first one was in the year of 1885, in which the Indian Telegraph Act is proposed and forced. The first recorded cybercrime incident is believed to be recorded in the year of 1820. Means before the Indian Telegraph Act 1885, in 1820 the first cybercrime is recorded. Now, why cyber law in India? So the cyberspace is a completely different sphere of the human existence. No regards for any government on territory. It means that there is no physically existence of the cyberspace. So everyone can feel that he can do anything in the cyberspace, but it will impact not only a person by any physical mean, but also by psychology mean. It will affect the society, it will affect the government too. So to regard this field, we required some law to facilitate international norms, because internet is working beyond the boundaries of any nation. So to facilitate the international law, we require the cyber law in India. Cyber law need to be specific. It means that we have to define each and every word, each and every term which is used in the cyber space. So we required a law to simply define a particular terms which are using in the cyberspace. So conventional law will muddled up the cyber law structure. It means that it's not sufficient. The conventional laws are not sufficient for to deal in the cyberspace. So we require the cyber law in India. Now, how the cyber law work? What is the cycle for the cyber law? Law practice is the initial thing. What happened? We got some cases of the cyber attack. How do we deal with those cases? So we require the cyber forensic and another tools to simply investigate those particular cases. Then we required some cyber security and IT experts to deal or to investigate these particular cases. Then we required some evidences and investigation to forward these cases to the result. So we require the cyber law now to simply proceed the case under the trial of the Nations Act or Nations Law. We require the cyber law now. These evidences and investigation will be accepted by the Nations Law. Then we can punish the cyber criminal. So this is a particular cycle for the cyber law. History of cyber law in India. The motivation for the cyber law in India is Model Law of Electronic Commerce, which is adopted by the Model Law on Electronic Commerce on International Trade Law on 30th January 1997 by General Assembly of United Nations as a resolution. United Nations is an agency, as we all know, that which deal with the beneficiary of the common man. So in 1997, UN proposed electronic commerce on international trade law. This is the motivation for the Indian government to propose the IT Act. So the outcome of the above resolution is Information Technology Act, and the UN recommended for its member states. In July 1998, the Department of Electronics of India drafted the bill, and we have IT Act 2000 and the IT Act Amendment 2008. So these are basically two laws which are existing in our law book now. Cyber law in India also added by many other acts, because existing laws in, say for example, IPC is for the punishment, and another law like Evidence Act, the Code for Criminal Procedure, and many other laws are existing in India. But because the mode of operations, the mode of evidences, the mode of investigation is changed, therefore cyber law have to added for these all existing acts and statutes. Now, to understand the cyber law, first we have to understand what is the cyber crime and how can we categorize this cyber crime. So classification of cyber crimes are basically, cyber crimes are distinguished in three basic categories. Number one is crimes against person or individual, crimes against property, crimes against state or society. So crimes against person or individuals means the cyber crime. Cyber crime means the crime in the internet. So cyber crimes against the person or individuals includes harassment via email. If someone doing harassment using the email, it comes under this category. And second is cyber stalking. Third is dissemination of obscene material. If someone forced to see a particular obscene material, so it comes under the crimes against person or individual. Defamation. If someone simply spreading a message in cyberspace to defame someone, So it comes under this particular category. Unauthorized control access over computer system. If someone simply try to access the systems of others, then it comes under this particular category. Another is incident exposure and internet time theft. For example, I have my internet connection from one ISP. If someone simply stealing this time, it comes under this particular category of cybercrime. Another is email spoofing. Email spoofing means if someone is send an email to other but using the email ID of other person, so it is as email spoofing. It's also a crime. Pornography, which includes child pornography. So these are cyber crimes, comes under the cyber crime against a person or an individual. Second category is crimes against property. So computer vandalism. Second is virus transmission. There is another cyber crime is virus transmission. It means we are simply affecting others' computer using the virus. It comes under this particular category of cyber crime. Denial of service attacks. Denial of service attack means we are simply sending a number of requests to a particular system or particular server in such a way that the server is unable to do further processing or unable to serve the genuine or legitimate requests. So it's called the DOS attack or denial of service attack. So this particular crime comes under the crimes against property. Another is unauthorized access over computer system. If someone is simply try to access remotely a particular system or server, it also comes under this particular category. Intellectual property crime. Intellectual property crime means suppose I simply propose one idea and someone is simply steal this idea. So it is the intellectual property crime. Another is financial scams and frauds. If someone simply try to access the pin of your ATM or other information of your credit card and try to transactions using that particular information, so it comes under this category. Sale of illegal articles. Suppose someone is saying that buy this product and this product will benefit to a customer by some means, but if that not possible or that not exist, so it is the sale of illegal articles. Another sale of illegal article means we are simply selling the drugs, the guns, etc., which are not legal. So it comes under the sale of illegal article. Another is hacking. So hacking means unauthorized access of any system. So it comes under this particular field, particular category, crimes against property. Now other category is crimes against state or society. So the first is intention to extract secret information from computer system. For example, if someone try to access the very secret data or what they say very secret information of government or a university, so it comes under this particular category. Cyber terrorism, simply enforce the ideology of terrorism using the cyberspace, it comes under this particular category. Distribution of private material, it means that I have my private information. If someone simply is spreading this private information to cyberspace, so it comes under this particular category. Polluting youth through indecent exposure. Illegal human trafficking online. I think we all are aware about this particular crime. Someone is simply sending a person to Canada or abroad but illegally using the cyberspace, so it comes under this particular category. Sale of illegal articles, online gambling, because gambling is not legal in our country, in our nation, so it also comes under this particular category. Unauthorized control over computer system. If someone is tried and do the control over a system or over a server but in an unauthorized manner, so it comes under this particular category of cybercrime. So these are the cybercrime categories, and I think we all are simply aware about these categories, or we are simply reading some news, some crimes in the newspaper or in the television about these particular categories of cyber crime. Now, the next is types of cyber law in India. It means how many type or how many categories of cyber laws are existing in our IT Act. So the IT Act 2000 can be categorized in three basic parts. Number one is administrative, two civil issues, three criminal and penal. So the administrative part of the IT Act 2000, it stands for recognizing e-commerce. E-commerce means if someone is providing the services using the cyberspace, so it comes under the e-commerce. E-governance is also a type of e-commerce application. Legal enforceability and authentication of electronic document. So the administrative part also deal with this particular field. Methodology and processes. Methodology and processes which are implemented over the cyberspace to facilitate the user. If someone is affect these methodology and processes, it comes under the administrative part of the IT Act. A special adjudicating officer and cyber law appellate tribunal also be established under this particular administrative law category. So their role and duties therein. So in the administrative part of the IT Act, they are enforcing some authority which deal with the IT Act and also provide the methodology and processes, provide the simply legal enforceability and authentication of electronic document process, and also recognizing the e-commerce. So the next part is the civil aspects. In civil aspects, IT Act elaborate that runs parallel to administrative venture of the IT Act. It means that the civil issue part or civil aspect of the IT Act running parallel to the administrative venture of the IT Act. It describes what constitutes civil infringement of the right. Through this part of the IT Act, it will be proved that which is legal or which is illegal for a person. It prescribes civil duties of a person or a group of person. Next part is criminal and the penal. So criminal part of the IT Act is recognizes and provides for penal measures against crime in cyberspace, digital crimes or crime against computer resource, related issues to redress, monitor, restrict, investigate cybercrime is also provided herein. It means that how do authority is go forward or proceed to investigation, so it comes under the criminal part of the IT Act. IT Act 2000 recognizes the cardinal philosophy of cyber disputes. And what is it? So it describes computer can be abused and computer are weapons as well as victims, because in cyber crimes the nodes are computers and these nodes are connected with the internet. So computers can be abused and computers are weapon as well as victim. So the term computer has wide amplitude in view of the IT Act. So what is the computer? It is defined in section 2 of the Act as computer means any electronic, magnetic, optical or other high speed data processing device or system which performs logical, arithmetic and memory function by manipulation of electronic, magnetic or optical impulses and includes all input output processing, storage, computer software or communication facilities which are connected or related to the computer in computer system or computer network is computer. It means that this definition simply covered all the devices, all the technologies, all the software, all the hardwares, all the storage devices, whatever we are simply assuming comes under the computer. Now the second definition is computer network. What is computer network in context of the IT Act? So computer network is the connection between single or multiple computers through the use of communication media using terrestrial lines, microwave, satellite, etc. It means two or more computers can be connected by any mean. So that connection established by the computer network. A terminal consisting of various one or more mutually connected computers, whether the interconnection is continuously maintained or not, it's called the terminal. So it means that computer network is connection of single or multiple terminals, and terminals are any computer system which is interconnected continuously or non-continuously, but it comes under the computer network. Now another definition, computer resource. Computer resource means computer, computer system, computer network, data, computer database or software. Computer system. Computer system means a device or collection of devices including input and output support devices, but not including calculators, which are not programmable and capable of being used in conjunction with external files, which contains computer programs, electronic instructions, input data or output data that performs logic, arithmetic, data storage and retrieval, communication, control and other functions. It means calculators are not computer system according to the IT Act because it is not programmable. 2008 IT amendment also comes in the picture, and some more definitions are also described in IT Act 2008. So the new amendment also defines cyber cafe, electronic signature, communication devices, cyber security and Indian CERT. Cyber cafe. The definition of cyber cafe is any facility from where access to the internet is afforded by any person in the ordinary course of business to the member of the public. It means any public place is providing the facility to access the internet, so it comes under the cyber cafe. It described in section 2 of 1 NA of IT Act 2000. Cyber security. So what is the cyber security? Protecting information, equipment, devices, computer resource, communication device and information stored therein from unauthorized access, use, disclosure, disruption, modification or destruction is cyber security. It means if we are providing the security to our systems from these unauthorized access or disclosure or disruption, modification or destruction is called the cyber security. Data. A representation of information, knowledge, facts, concepts or instructions which are being prepared or have been prepared in a formalized manner and is intended to be processed, is being processed or has been processed in a computer system or computer network and may be in any form including computer printouts, magnetic or optical storage media, punched cards, punched tapes, etc. or storage internally in the memory of the computer is called the data. Digital signatures. It is very important for non-repudiation and also authentication. So what is digital signature according to IT Act? Authentication of any electronic record by a subscriber by means of an electronic method or procedure in accordance with the provision of section 3 of IT Act 2000. What is electronic form? With reference to information means any information generated, sent, received or stored in media, magnetic, optical computer memory, microfilm, computer generated microfiche or similar devices is electronic form. Electronic record. It described in section 21T of IT Act 2000. It means data record or data generated, image or sound stored, received or sent in the electronic form or microfilm or computer generated microfiche is electronic record. Key pair. It is very important to understand what is the key pair according to the IT Act, because for the digital signature or for the security purpose we require the key pair. So according to the IT Act 2000 section 2110, which describe the key pair, is an asymmetric crypto system, means a private key and its mathematically related public key, which are so related that the public key can verify a digital signature created by the private key. So key pair consisting two keys, one is private key and another is public key. In digital signature, private key is used to simply generate a code which is called as a digital signature, but on the other end, public key is used to validate or verify that particular code such that the code is generated by a legitimate user or not. Originator, a person who sends, generates, stores or transmits any electronic message or causes any electronic message to be sent, generated, stored or transmitted to any other person but does not include an intermediary, is called the originator. So this definition is described in section 21 ZA of IT Act 2000. There are two other definitions very important: private key and public key. So what is private key? According to the IT Act 2000 section 21 ZC, private key means the key of a key pair used to create a digital signature. And what is the public key? According to the section 21 ZD of the IT Act 2000, public key means the key of a key pair used to verify a digital signature and listed in the digital signature certificate. Secure system. According to the section 21 ZE of the IT Act 2000, secure system can be described as computer hardware, software and procedures such that these are reasonably secure from unauthorized access and misuse. These provide a reasonable level of reliability and correct operation. These are reasonably suited to performing the intended functions and adhere to generally accepted security procedures or secure systems. So according to this act, we can define the secure system and anyone can certify the system is secure or not according to this particular act. Now we go further for some sections of the IT Act. Section 4, legal recognition of electronic records. So this section provides the legitimacy of the electronic records. So according to this section, if any information is required in printed or written form under any law, the information provided in electronic form which is accessible so as to be usable for subsequent use shall be deemed to satisfy the requirement of presenting the document in writing or printed form. So a general provision of recognizing electronic documents comes under this section. Another sections related to the e-governance are 5, 6, 7, 9 and 10. Section 5 describes legal recognition of electronic signature. Means what is electronic signature and how do electronic signature recognize legally comes under the section 5. Section 6 describes use of electronic records and signatures in government and its agencies. So this section enforces government and its agencies to use electronic records and digital signatures. Section 7 and 7A describes retention of electronic records and audits. Section 8 describes publications of rules and regulations in the e-gazettes. Therefore, you all are aware that e-gazettes comes under the picture and we all get the e-gazettes using the government site. Section 9 describes no right to claim and insist on electronic documents. Section 10 describes central government retains the power to make rules with respect to electronic signatures, type, manner, format and processes whatever used to establish or develop the electronic signature. So this autonomy is given to the central government under the section 10. Section 11 and 12 describes receipt and acknowledgement of the digital documents. Section 11 discuss about the attributor, that is sender of electronic record, or by a person authorized by any other, or by an auto response duly programmed on behalf of the other, is recipient or sender. Section 12 describes receipt for acknowledgement where nothing has been stipulated. So any communication from addresses, automated or otherwise, any conduct of the address that proves sufficiently. However, conditions may be imposed by the attributor via an email, footer and statement therein. It means that if someone is sending the electronic document, so the other party should provide the receipt or acknowledgement of that particular document. Other important sections are section 16, central government to prescribe security procedures, and it will be changed according to the technology change. It comes under the section 16. Section 17 to 34, it deals with the appointment and regulation of controller and certify authority. So we required a number of certified authorities and number of controllers to simply regulate the cyber law. So the appointment of these authorities comes under section 1734. Section 35 to 39 describes obtaining digital signature certificates. So how a person, how a society, how government obtaining digital signatures, and so these all processes and methods are described in the section 35 to 39. Section 40 to 42, it describes the duties of subscriber of DSC, exercise due care to retain the private key. Now, administrative character can be described in the section 44. It describes the penalty for failure to furnish information and return, etc. Appointment and function of educating officer describes in section 44. Powers and functioning of the cyber law appellates tribunal is also comes under the section 44. Section 61 describes civil court excluded from jurisdiction. Section 46 and 21C describe educating officer. Who should be the educating officer? What is the functioning, what is the work, what is the authority of educating officer is described in this particular section. Offense and gist. Section 43 describes the simple civil provision. Now a civil and many amount to a penal offences under section 66 if a fraudulent or dishonest means is established. So it relates to access to computer without the permission of the computer owner. It penalizes any sort of unauthorized access or assistance. Very interesting thing is that we all are once trying to access the computer system or phone of our friend, but without the permission of our friend. So it is the unauthorized access. So it comes under section 43 and it is punishable offense under the IT Act. Section 43 in a nutshell can be described as whoever without permission of owner of the computer secures, disrupts access of computer, digital resources or network comes under the section 43. Downloads, copies, extracts any data unauthorizedly from the other computer comes under this particular section. Introduces or causes to be introduced any virus or contaminant also comes in section 43. Damages or causes to be damaged any computer resource, destroy, alter, delete, add, modify or rearrange, change the format of a file, disrupts or cause disruption of any computer resource, preventing normal continuance of computer. So these comes under the section 43. Now section 43A is about the failure to protect data. If someone is claiming to protect the data but it fails, then the offenses comes under the 43A. So 43 is very important to understand. We have to learn about the 43. So without any permission of a computer owner, we do not try to access that particular system. And this is not a computer system, this is also mobile, whatever it is, but the computer system according to the IT Act. Some other important points about the IT Act. Section 65. Section 65 describes the offense about tampering with computer source documents, and the punishment is imprisonment up to 3 years or fine up to rupees 2 lakh or both. So this is a punishable task. Section 66 penalizes any contravention under section 43 if carried out with a fraudulent or dishonest motive, then it comes under section 66, and the punishment should be imprisonment up to 3 years or fine up to rupees 5 lakh or both based on the severity of the fraudulent. Section 66A, punishment for sending offensive message through communication services like internet or messaging or WhatsApp, whatever it is. So it comes under the section 66A. Offensive or menacing or false or for the purpose of annoyance, inconvenience, ill will, etc. comes under the section 66A. So the punishment of this section is up to 3 years and with fine. Section 66B, punishment for dishonesty, receiving stolen computer resources, etc. If someone simply receiving the data which is stolen by another, it comes under the section 66B. Section 66C punishes identity theft, password or other passphrases, unique identification or authentication credentials. It comes under the section 66C. Section 66D defines, punishes personating by means of computer resources. Section 66E describes, punishes violation of privacy rights, and section 66F describes, punishes cyber terrorism. So these are very important sections. We all are aware about these sections. Now other section is 67A, punishment for publishing or transmitting of material containing sexually explicit act, pornography, etc. in the electronic form is comes under the section 67A. Punishment is first conviction. Any person do this first time, the imprisonment up to 5 years and fine up to rupees 10 lakhs. But if it will repeat it, then second conviction, imprisonment up to 7 years and fine up to 10 lakhs. It's described in section 67A. But some important things are exceptions for this 67A Act, as if someone using the same material for the art, science, literature or other interests of learning and other cases, these all are exempted from punishment. Section 67B, punishment for publishing or transmitting of material depicting children in sexual explicit act in the electronic form. If the same which is described in 66A is for the children, then it comes under section 67B. So the first time convicted people is punished with imprisonment up to 5 years and fine up to rupees 10 lakhs. And for the second conviction, imprisonment up to 7 years and fine up to 10 lakhs. Section 67C, preservation and retention of information by intermediaries, means if I am simply sending an information and my ISP store that information, so it's a punishable offense, and the punishment should be imprisonment up to 3 years and with fine. Section 68, provision and punishment for violation of order from the controller. If controller give one order and someone is violate that particular order, it comes under the section 68. Section 69 describes power of the government to issue direction for monitoring, intercepting or decrypting any information through any computer resource. Some other important subsections of section 69, 69A and 69B. 69A describes the power for blocking of public access. I think you all are listening some news in television or simply reading in newspaper about the blocking of internet access for vulnerable areas like J&K and other pawn areas. So those are under the section 69A, where government has power to blocking the public access of internet or telephone services. Section 69B provides the power to the government to monitor and collect internet traffic or network traffic. So basically an administrative right of the government and provide for punishment to the violator, usually intermediaries who are in charge of some databases or are service providers. So now comes to another sections. Section 71, penalty for misrepresentation before the controller or the certifying authority. So the punishment is imprisonment up to 2 years or fine up to 1 lakh or both. Section 72 describes the penalty for breach of confidentiality and privacy. The provision applies to those persons who are empowered under this act with such a database or record. So the punishment is imprisonment up to 2 years or fine up to 1 lakh or both. Section 72A, penalty for disclosure of information in breach of lawful contract. An amendment to include even the employees of private organizations or such intermediary working therein. So if someone is supposed not to disclose the information, if he will simply disclose the information, this offense comes under the section 72A. The punishment is imprisonment up to 3 years or fine up to 5 lakh or both based on the severity of the act. Section 74, publication of signature or signature certificates for fraudulent purpose. It comes under the section 74. So the punishment is imprisonment up to 2 years or fine up to 1 lakh or both. Section 76, it provides for confiscation of any related computer accessory, system, part, etc. if the someone is believed to be used in any violation of this act or rules. Section 77B, offences punishable with imprisonment up to 3 years to be bailable. Section 78 describes the power to investigate offences now available to inspector. Earlier, the onus was on the DSP rank officer or above. It means that if someone is supposed to do investigation, then it comes under the section 78. Section 79, exemption of intermediaries and service providers if they establish that they have exercised due diligence on their part. So an abusive provision for the ISPs, but often helpful. The 2009 notification makes it an offense to even abet or attempt a cybercrime. Earlier, unsuccessful criminal always escaped by virtue of this gray area, because in this particular situation, the things are not clear. Section 84B, punishment for abatement. So same punishment as prescribed for the offense. Next is section 84C, punishment for attempt. A maximum of 1/2 of the term of imprisonment provided for the offense or with fine as prescribed for the offense or with both comes under the section 84C. Section 90 provides the power to the state government to make allied rules. It means that in section 90, state governments under the federal structure of India has powers to make allied rules and regulations for the cyberspace, cyber law, IT Act. So it's up to the state government. If they believe that they required more rules or more acts, they can propose and pass those laws from the legislature channel. Sending threatening messages by email. It comes under the section 503 of IPC. It's a criminal intimidation. It means that you are simply threatening to other using the any electronic meal such as email, comes under the section 503. Another is sending defamatory message by email. So if someone is simply spreading defamatory message for a particular person through the email, so it comes under the section 499 and 500 of IPC. And this act or this offence is entitled for the simple imprisonment, which may extend to for the 2 years and or with the fine. Forging electronic records. It means that someone is simply forged the records, electronic records. It comes under the section 463, 470, 471 of IPC. It entitles for the simple imprisonment, which may extend to for the 2 years and with the fine. Bogus websites or cyber frauds. The phishing attack. Phishing attack means if suppose there is a particular bank website, if some attackers create the website which is very similar to the original one, but it's a phishing, it's a simply for the fraud purpose. So this particular type of cyber crimes come under the section 420 of IPC. So the maximum imprisonment is up to 7 years with or without fine. Email spoofing. Email spoofing means if we are simply supposed to mail someone using the email ID of other, is called the email spoofing. So it comes under the section 416, 417, 463 of IPC, and it entitles for the simple imprisonment, which may extend to for the 2 years and or with the fine. Now other is online sale of drugs. If someone simply provide drugs on website, so it comes under the Narcotic Drug and Psychotropic Substances Act, NDPS Act. So regress imprisonment 10 to 20 years, fine rupees 1 lakh to 2 lakh regardless of the quantity. So this is the punishment for this particular offense. Web jacking, it means web extortion. So it comes under the section 383 IPC and entitled for the imprisonment, which may extend to for the 3 years and or with the fine. If someone provide the sale of arms online, it comes under the Arms Act and it entitled for the imprisonment not less than 3 years, which may extend to for the 7 years and with the fine. So these are very important cyber law and IT acts related with the IPC. So the very important other part of the IT Act is Evidence Act, because evidence is mandatory part for the legal proceeding. So the major highlights of the Evidence Act in view of the IT Act 2000 is that it recognizes electronic evidence. Section 65 describes the most important provision dealing with the specific provision on digital evidence. Section 65B describes the provision to provide for a detailed process for the analysis of the digital evidence in question. Section 65B(4) requires a certificate from the examiner of the digital evidence. It means if someone simply claimed the digital document, so it should be examined by the examiner and it should be certified by that particular examiner, which is governed by the government. The government shall notify who is the gadget examiner for digital evidence under section 79A of the IT Act. The same provision is exclusive. It includes all other cyber forensic experts from entering this field under section 45 of the Evidence Act. Keep altering the time clock? No, never. We do not keep the PC infected with viruses and Trojan horses. We do not use modified kernels of the OS. Someone simply use the phone which is called the modified phones. So the kernels are updated. So it's cause for the cyber crime. Use known applications and legitimate and certified applications. Never use the unknown applications. Do not keep the PC in defective mode. Use hardware that is not difficult to find. So these are some points to exercise in our working for the digital world. And the most important is, never try any trick which directly correlates with an attempt to destroy evidences.